So with that, I am going to get ready to turn this call over to our speaker today, which we are so pleased to have David Swerdlow from Windels Marx. He is a partner in the firm there, and he specializes in insurance-related litigation and regulation. And we were so fortunate to have him draft the amicus brief that New Jersey Civil Justice filed in the Wadiali case. So with nothing further, I'm going to turn it over to David.
Thank you, Emily. Good afternoon, everyone. As you all know, there were two cases argued on Tuesday before the New Jersey Supreme Court, which are going to no doubt have an important substantive and procedural impact on bad faith law in New Jersey. From the procedural side of things, the main question is, when does a bad faith claim accrue? When is an insured required to raise the bad faith claim, and what requirements will they have? What type of notice will they have to give to the insurance company? From the substantive point of view, which is probably of the most concern to most of the people on this call, particularly the industry, is what is the standard for bad faith going forward? Is it going to continue to be the Pickett fairly debatable standard, or is the court going to tinker with that, modify it, and I guess from the plaintiff's bar's perspective, make it easier to pursue a bad faith claim? I think the overriding theme, my sense from attending the arguments, the court was concerned with, the court recognized a carrier should have the opportunity to debate a question, to litigate when it feels that there's a claim that needs to be litigated. But it was also concerned about the consequences to an insurance company when it litigates that claim, it denies coverage, litigates, and it's later held to have been wrong in its evaluation. What should the consequences be, if any, to the insurance carrier? With that sort of preliminary intro, I'll give you a brief background of the two cases, and then, as I understand, this is, there's a lot of talk about these cases, so I'll be happy to open it up to questions and discussion. I'll start with the Wadiali case. That's the case where the Civil Justice Institute appeared as amicus. Wadiali is first and foremost an entire controversy doctrine case. It involves a claim of an NJM insured. The insured claimed that the accident was caused by a phantom driver. There were no witnesses to support that claim. NJM did not settle the claim. The case went to trial and resulted in an excess verdict in favor of the insured. There was a $100,000 policy limit, and there was a $255,000 excess judgment. The court, the insured then filed a second lawsuit alleging bad faith, claiming it was entitled to recover the full amount of the excess verdict. NJM in the trial court filed for summary judgment, arguing that the second bad faith claim was barred by the entire controversy doctrine, as well as on principles of res judicata. NJM prevailed in the trial court. The plaintiff appealed. NJM raised the same arguments on appeal, prevailed there as well on the entire controversy doctrine issue. The Supreme Court then granted certification, and that got us to where we were on Tuesday. The technical entire controversy doctrine issue is really, when does the bad faith claim accrue? Is it when the carrier denies the claim? Is it when the verdict comes in and there's an excess judgment? I think that people certainly, Many people have disagreed on that. My personal view is that when a carrier, under the existing law, when a carrier denies a claim without having any fairly debatable basis for doing so, that's when the bad faith claim accrues. I understand that other people think differently, and the plaintiffs in this case in particular were arguing that their bad faith claim didn't arise until the excess verdict was rendered. I think that the driving concern for the court in this case was its sense of fairness. I think the court recognized the competing views as to when the claim accrues, but my sense on the argument was that the court was concerned about the consequences to the carrier. It didn't seem to sit right with the court that the carrier could deny the claim, dispute coverage, go to trial, get hit with an excess verdict, have it molded to the judgment, to the $100,000 policy limit, and then have no consequences for that result, for litigating its position and losing. And I think that's what's going to drive the court on this case as well as on the other case, which I'll get to in a minute. The argument on the entire controversy doctrine in Wadier was, frankly, sort of anticlimactic. The plaintiffs argued that the bad faith claim accrued after the verdict, and the carrier said it really had no problem with that result. And the justices were, I think, very appreciative of that position. The justices characterized that as really a good result for everyone. It means that the carriers do not have to, if the bad faith claim does not accrue until the verdict, the carrier is not going to have to deal with discovery in defending a bad faith claim during the course of the underlying contract claim. My view on that is, it's hard to predict where the court's, exactly what the court will say in its decision, but as a practical matter, I don't know that there's going to be a real difference in how these claims are currently being handled. Right now, when there's a bad faith claim that's brought with the underlying claim or breach of contract claim, typically those cases, the bad faith claims are severed from the underlying claim. Discovery is held in abeyance. Most of these claims are going to settle at some point during the litigation process. Those of them that go to verdict, I think generally speaking, there's going to be a result, a verdict somewhere within the policy limit, and the carrier will pay that. And then you're going to have a few of these cases, like the Wadier case, like the Tadai case, which I know many of you are familiar with from a couple of years ago, are going to end up with excess verdicts. And in those situations, I think that carriers are going to have to defend bad faith claims, and they're going to have to do it in the face of an excess verdict, which could pose some problems. Just at the same time, however, I don't know that. I think that that's the way things typically play out now. I don't think that the Supreme Court decision in this case is really going to have a real great impact on that. Let me move quickly to the second case that was argued. Well, it was the first case that was argued before the Supreme Court, Badiali versus NJM. And I think this is the case that the oral argument was certainly far more engaged, and I think it's touched more upon the substantive evaluation of a bad faith claim. Just real quickly, by way of background, this was a rear-end accident. The insured had coverage apparently through two carriers, NJM and Harleysville. The arbitration award was $29,000, and each carrier was responsible for $14,000, $14,500 of that. NJM, under its policy language, rejected the award, and the issue was really a straightforward issue of whether the NJM policy language allowed NJM to reject the award, which was the award was $29,000, but its responsibility was less than the $15,000 minimum, and the question was whether in that, since NJM was only responsible for less than $15,000, did it have the right to reject the arbitration award and require a de novo trial? That was the underlying issue. The plaintiff actually, after NJM rejected the award, filed suit and prevailed. The trial court held that NJM was not allowed to reject the arbitration award. It was binding. NJM appealed. The appellate division affirmed. The plaintiff filed a second lawsuit alleging bad faith, arguing that NJM's position in the underlying Badiali case was bad faith in seeking to recover attorney's fees and other consequential damages. The court was very interested in these issues and the conduct in this case, mostly the fact that we're talking about a $14,000 exposure to NJM and litigation that carry on for the course of 6 years. Justice Albin was extremely vocal in his stance. He stated that the system, that there was something systematically wrong with this, that a carrier can deny coverage, force its policyholder to litigate for 6 years, and then 6 years over $14,000, and then at the end of the day only be responsible for that $14,000 arbitration award with no other consequences. All that said, the justices were sensitive to the carrier's rights and ability to be able to defend its position. My take is that they thought that NJM's interpretation and arguments in favor of its position were certainly made in good faith and were legitimate arguments. The question, I think, in the justice's mind, though, was should there be any consequences for NJM and any carrier in that position when it loses on its position? And I think that's where this case is going to go. What are the consequences to an insurance carrier who debates a question, who litigates a question, and then ultimately loses in its coverage position? And the questioning from the various justices was geared towards what consequences might there be? What should the court do? And different justices raised different points. Justice Albin, he talked about amending the court rules to allow for fee shifting in this circumstance. Currently, the court rules, Rule 442.9, allows fees to be shifted in favor of a successful claimant under a liability or indemnity policy. The courts, though, have interpreted that and applied that language to apply only to third-party liability claims. That court rule does not apply in connection with a first-party insurance claim. And Justice Albin posited, wouldn't a quick simple fix be just to amend that rule to allow the attorney's fees in favor of the insured in the event the insurance company litigates and is unsuccessful in asserting its position. I thought that in response to that, NJM's counsel, Dan Pomeroy, had a very good response. He said, Justices, there's been a lot of talk about fairness here. You know, fairness is a two-way street. If you're going to amend the court rule, it should be you should amend it both ways so that the losing party, even if that's the insured, should be responsible for paying fees. I'd be very surprised if the court goes that far. Even the rule as currently drafted says that the successful claimant, meaning the insured, can get fees when it comes to a liability policy issue, but the carrier on that end cannot get fees. So although I think it's an extremely strong point, a fair point, I'd be very surprised if there's any type of amendment to the rule which allows both sides to get attorney's fees in the event it prevails on its position. Justice Fernandez-Vina, he raised another possible remedy, the offer of judgment rule. Can't the insured get their consequential damages, their attorney's fees, their expert costs, and enhanced interest under the offer of judgment rule? And I think that's also another very strong remedy. Frankly, that offer of judgment rule already provides a very strong incentive to insurance carriers to look closely at a claim. If you've got a $100,000 policy limit and you're faced with potential offer of judgment sanctions, that can get up into the $50,000 or $60,000 range. And in my experience, carriers take those offers of judgment very seriously in formulating its position in a case. The one problem with the offer of judgment rule that the plaintiffs bar and NJCJI, formerly ATLA, pointed out was that there is currently an issue with the rule in that it's measured against the consequences of the offer of judgment rule are measured against the judgment, the molded judgment, and not the excess verdict. So a policyholder who thinks that he's got a slam dunk for $200,000 in damages with a $100,000 policy limit, if he wants to recover on the offer of judgment rule, he's actually going to have to make a demand for $80,000. And they say that that's unfair when the value of their claim is so high. I think that the court was sensitive to that argument, and they talked about possibly amending the offer of judgment rule in this context to allow the offer of judgment to be measured against the verdict and not the judgment. Some of you may recall that proposal was actually raised a couple of years ago, but it was never adopted. I suspect that the court's going to take a much closer look at it now. One of the other justices, Justice Solomon, he said, is the remedy for an insured who prevails on his claim, can he pursue a claim under the frivolous litigation statute? That might also allow the insured to recover his attorney's fees and other costs. I don't think that there wasn't a lot of discussion on that. I don't think that's really a realistic result here. It's extremely hard to get sanctions under the frivolous litigation statute. The last issue that was talked about, and the other possible remedy is the bad faith remedy. If the carrier defends its position and loses, what are the consequences? Should the issue for bad faith, should it continue to be the fairly debatable standard? Should it be something else? Should it be, if a claim is fairly debatable, does that end the inquiry into a carrier's bad faith, or should the plaintiff be allowed to do some more discovery into the insurance company's subjective evaluation or point of view in the claim? In other words, just because a claim is fairly debatable should the insured still be allowed to look at the insurer's internal processes, claim file, and explore its evaluation of the claim to see if there wasn't something else motivating its decision or its litigation stance. Another, I guess, topic of questioning that came up is along the lines of what should the bad faith standard be is, why do we have a difference between in the first-party context and the third-party context? Why in first-party claims do courts apply a fairly debatable standard, and why in the third-party Roba Farms context is there more of a totality of the circumstances evaluation in determining the bad faith? And I thought that NJM's attorney in that case also did a fine job distinguishing between the reasonings for the first-party claims and the third-party claims. That's though where I think the most interesting part of these cases will be is what is the court going to do? Is it going to tinker with the bad faith standard, or is it going to create some other type of remedy to create some other potential consequence for a carrier who should be entitled to litigate its position, but at the end of the day is unsuccessful in that position? Should the insured have some type of remedy in that case? And my sense is that the court is going to give them a remedy, and it's going to range somewhere in between, an amendment to the rules, amendment to the offer of judgment, or the fee-shifting rules to allow them to recover attorney's fees, to some sort of modification of a bad faith standard to make it easier for a plaintiff to prevail in that regard, and to let the insurer know that there are going to be some consequences if it wants to live beyond its policy limits in the event that it wants to litigate a claim and is unsuccessful in that position. With that, that's sort of my background of the cases. I'm happy to open this up to any questions or discussion.
Great. Thank you, David. That was very informative. Like David said, we're going to go ahead and take questions now. I have a couple here that I have had emailed to me. The first one is that the oral arguments didn't exactly go how we were expecting them to go. There was sort of a shift in strategy that day. Can you address that, David?
Yeah. I can certainly address that there was an apparent shift in strategy. It's hard for me. I can speculate as to why that is, but I obviously wasn't involved in the decision. Like I said, in the Wadir case, the entire controversy doctrine case, NJM argued in the trial court and the appellate division that the claim was clearly barred by the entire controversy doctrine. It asserted that position as well in its briefs to the Supreme Court. And then at the oral argument, I think there were some people, including some of the justices, who were a little bit surprised when NJM conceded that it didn't like the entire controversy doctrine and frankly didn't appear to have any problem with the court abandoning it in the context of this particular case. And I think that the reasoning for that, I suspect that the reasoning is that, the result that a carrier, that an insured cannot bring a bad faith claim until after the verdict is not a bad result for the insurance industry. Some people have argued, some plaintiffs have argued that the Wadir case, the Tadai case, forced plaintiffs to file bad faith claims at the outset. I've spoken with different carriers. They have different views on that. Frankly, carriers were seeing bad faith claims brought along with underlying UM claims before Tadai, before Wadir, and they continued seeing them afterwards. But I think that NJM's position, or I assume it was born of the fact that, hey, at the end of the day, it's not a bad thing if bad faith claims have to await the outcome of the underlying claim. As I alluded to, and I agree with that, as I alluded to before, I think as a practical matter, I think that already happens, because when the claims are brought, these days, I suspect the great majority of the time, the claims are severed. The bad faith claim is severed and held in abeyance, either by consent of the parties or by motion. And then after the underlying claim is resolved, either by settlement or litigation, the bad faith claim more often than not goes away. So I don't know that practically there's going to be a real difference in the way these claims are handled, but I suspect that the carrier's position in this case was motivated by the fact that, we don't really have a problem if the court wants to hold that bad faith claims don't accrue until after a jury verdict. There are other interesting issues about that. Here we're talking about a first-party UIM claim, which involves, subjective bodily injuries and, placing a value on that. It's different than a homeowner's property damage bad faith claim. In that context, I think bad faith claims almost routinely are brought with the underlying claim. It'll be interesting to see if the court rules that a bad faith claim can't be brought until the underlying breach of contract claim is resolved. Obviously, its decision will be in the context. It'll be interesting to see if the decision is limited to that context, or if it also extends more broadly to bad faith in general, to the entire, to all insurance claims where bad faith claims typically accompany a denial, a breach of contract claim following a denial of a claim.
Thanks, David. I have another question here. Did the industry groups join in with NJM's argument of accrual of bad faith?
The industry did. The counsel for ICNJ did seem to accede to that position as well in his argument, and I assume again it was for the same reasons.
Hi, David. Thank you so much for that discussion. I just had a question about the discussion at oral argument about the carrier's fiduciary duty to the claimant. Justice Alden seemed to be very concerned about that fiduciary duty to someone who he said had been paying premiums for presumably a very long time, and curious what your thoughts were on that angle.
Yeah, that's an argument that's routinely made by insured's attorneys, that insurance companies owe a fiduciary duty to its insureds. I agree with NJM's position on that. It's in my view, it's a far more nuanced argument. The Rova Farms case, which is the seminal bad faith claim in a third-party context, clearly talks about an insurance company having a fiduciary duty to its insured. But as we all know, the Rova Farms involves a liability, the exposure of an insured to a personal judgment. And when they go to their carrier asking for the defense, the carrier is protected by the policy limits, but the insured is not necessarily protected by the policy limits in the event of an excess judgment. And in that circumstance, in that context, the court held clearly that the carrier has a fiduciary duty to try to settle the claim and to protect its insured. It cannot value its own interests over that of the insured. But when you read that case, it talks about it's peculiar to this third-party situation where a carrier is defending its insured. Now, there is no, at least from that I'm aware of, I'm not aware of any cases on the first-party side in New Jersey which explicitly state that the carrier, in responding to a first-party claim, owes a fiduciary duty to its insured. And I think counsel for NJM in that case, Rich Williams, clearly and forcefully made that distinction.
Yeah, and as I recall, Justice Albin's response was to cite the Allstate ads, just the sort of the very vague claims in advertising that you're in good hands.
Yeah, if you're in good hands, you owe a fiduciary duty. And Justice Albin was also talking about, these guys, your insureds are paying premiums for years. Shouldn't they be getting the benefit of the doubt here?
Right.
And I think there was, he did step back a little bit. He said, well, even if it's not a fiduciary duty, it's a real strong duty. It's maybe something sort of fiduciary, but certainly the carrier owes an enhanced type of duty to its insured who's paying premiums over the years and who's relying on, on good hands or for its carrier to protect it, protect him or her. And, and again, the response was, this is a first-party contract. The contract dictates the coverage, and evaluating this, we acknowledge that we owe a duty to the insured, but we also owe duty to our insureds as a whole not to pay claims that are not covered. And so we need, from the industry side, from the carrier side, we need, we need to take a big picture approach to this. We're just because a policyholder has paid premiums for 5 years, it doesn't mean that when they have a claim in the 6th year that they're going to be paid. It's going to be an objective determination based on the facts of the particular loss. But I do think that there is an opportunity here for Justice Albin or any of the justices to come out with a declaration that this so-called fiduciary duty also applies to a carrier in the first-party context.
I actually have a question for you, David. I was surprised by the amount of argument that they took concerning laws from other jurisdictions. Is that persuasive, since this is something that was, the law in this particular case is something that was taken from Rhode Island, or is that at all typical? I'm just curious.
That is typical. I think in fashioning a remedy or a decision here, especially if the court is going to look at tinkering with the bad faith standard, it's going to look at what other cases, what other jurisdictions have done. And the plaintiff's bar was very aggressive. The Pickett fairly debatable standard relies on a Rhode Island case. Subsequent to Pickett, though, the Rhode Island court modified its bad faith standard. It said it continued to maintain the fairly debatable standard for bad faith, but then went on to say that there might still be cases where there's bad faith even if the carrier had a fairly debatable basis for its position. And that's the question. Some of the justices were questioning that if a claim is fairly debatable, does that end the story? And they were a bit incisive with the plaintiff's bar. What discovery is it that you're going to want to take if an insurance company has a fairly debatable position? Where do you want to go with this? I don't think, in my view, there wasn't a real strong response. It was, well, we'd like to take the deposition of the adjuster, maybe a claims committee folks, maybe get some internal guides, all that said. But the court came back to, but if the claim is fairly debatable, are you really going anywhere with that? and so it was hard to predict where they were leaning on that issue. Like I said, my overall sense is that they think that there should be consequences when a carrier denies it, asserts its position but is unsuccessful. But at the same time, I didn't get the sense that they really wanted to go too far in modifying the fairly debatable standard. But like I said, Emily, going back to your question, they certainly will look at other cases. The briefing, you're right, there was a lot of discussion of other cases, other jurisdictions. That wasn't extensively, those other cases were not extensively briefed before the court. I had the sense that, from the defense side, they talked about a lot of cases, and they just wanted to get that before the court to let them know, hey, if you're really thinking about tinkering with the fairly debatable standard, here are how other jurisdictions are handling it. And I think NJM's attorney said that 19 courts follow the fairly debatable standard, and then started articulating the standards from other jurisdictions, which apparently have an even stringent standard for determining bad faith. And I think the point of that is, hey, justices, if you're going down this road, the fairly debatable standard overall, it's pretty well accepted. It's a pretty good standard, and there are you could do a lot. If you're an insured, you could do a lot worse in some of these other states.
Interesting. Thank you. I've gotten another question by email, and the questioner asked, can you clarify the position taken by plaintiffs that a reasonableness standard should apply in lieu of fairly debatable? What's the difference?
That's an excellent question. I don't think that the plaintiffs were able to really articulate a distinction between a debatable reason, a debatable position, and a reasonable position. I think, again, having read the briefs and having dealt with some of these attorneys in other cases, I think where they're going is they just want a standard that says, just because a claim is fairly debatable, it doesn't get the insurance carrier off the hook of bad faith. There are a lot of subjective issues that go into the assessment of bad faith. Did the insurance company conduct a reasonable investigation? Did it, the plaintiff's bar and the plaintiff's briefs in these cases, all of them seem to say, without any justification or support in the record, that insurance carriers are just making up explanations once they get into court. They're making up any reason, any possible explanation for a denial of a claim, and courts are buying that and dismissing the cases without giving the plaintiffs an opportunity to conduct any discovery. I don't know where that comes from. I've never seen a carrier just make something up. I mean, you look at the claim file for those of us who do the defense work, and there's always an explanation, a basis for the position that it takes. It's not always right, but there's certainly a logical basis. I think what the plaintiffs are trying to say is, even if a carrier has a debatable reason, we think that there might be something going on here, and so we want to explore whether a carrier did a reasonable investigation, whether it spoke to all the necessary witnesses, whether it hired appropriate experts or engineers, whatever the case may be, to help evaluate the claim. They want to look at and see what the investigation was and see if it was, in their view, reasonable. In my, I guess you might call it jaded sense or opinion, I I think the goal is just to get beyond a summary judgment motion, and by throwing reasonable out as the standard, that's sort of the catchphrase for a jury question. If the question is whether a carrier had conducted a reasonable investigation, performed a reasonable evaluation, that's a the plaintiffs want that to be a subjective evaluation and have it go to a jury to get beyond a summary judgment motion, hoping that that the threat of a bad faith exposure will help lead to an enhanced settlement. I think that's the goal of the plaintiffs in trying to draw a distinction between a debatable reason and a debatable position and an unreasonable investigation. I think that with all that said, I'm not so sure that at the end of the day there's a real great distinction, but I think the plaintiff's bar thinks that there is.
Hi, thank you, David. Was there a discussion in the argument in the first case about whether an unpublished opinion was sufficient to rely on to make a decision reasonably debatable?
There was some discussion, although it was certainly not the focus of the argument. If I recall correctly, Justice Sullivan said, he took the position that the unpublished decision has it doesn't mean anything. It shouldn't have any effect. Some of the other justices said, well, you don't need the unpublished opinion to articulate the legal basis, the interpretation of the policy. Justice Fernandez-Vina, I think he said, NJM certainly can argue that its interpretation of the policy language allowed it to reject an arbitration award based on the language of the policy itself. It didn't need that unpublished decision. That was further support and helpful to its position, but it certainly could articulate the same explanation, the same basis for applying its policy language without any unpublished appellate decision. So, short answer is there was some discussion about that. I don't think that's going to be the focus of that didn't appear to be the focus of the court's questioning or where it's going with this case. My sense was that the court's, if three appellate judges, even if it's an unpublished decision, are agreeing with the carrier, that goes a long way towards at least establishing a fairly debatable interpretation of the policy.
Yeah, exactly. That was why. I mean, I wondered if I was missing something. That was exactly why I found it confusing. Was exactly as you say. This is something that an appellate division panel signed off on, and yet it's not even fairly debatable. Seemed to be a stretch to argue as
what the plaintiff argued in that case is that NJM didn't raise that appellate division decision until I don't know if it was. I think it was until the appellate.
Right. Yes, they were yes, exactly. They were suggesting that. I guess maybe both. That also that it because it wasn't raised earlier in the process, they weren't actually relying on it when they made the decision. Which then, right.
And I sort of agree with Justice Fernandez-Vina and I think Justice Solomon. NJM could reach that determination without being aware of that decision.
Right, for the same reasons, presumably, that the appellate panel reached it independently, right?
Right.
Right. And then my second question was something that you mentioned just recently about whether one of the motivating factors in terms of reevaluating the standard for bad faith is maybe not even so much the stringency of it, but the predictability of it. That if you make the standard less predictable, that just the sort of the simple calculus, if you can take a potential bad faith claim off the table, the value that you give to a potential judgment is more predictable and therefore easier to value.
So,
does that make sense?
Let me just make sure I understand. So that's a justification in your view for.
I'm wondering if that's maybe if you're suggesting that it's the differing potential standards maybe don't have that much of a difference, even if the sort of the overall scope is similar. If one is more predictable, then that might help value the case. If one's less predictable, if it makes it harder to value, then the sort of the outer limit of what you might be able to extract in a claim, if the sort of the prospect of a bad faith claim is on the table, the plaintiff side just might be hoping that the calculus becomes less predictable and therefore they just get larger recoveries.
I think that's right. And let me go, the question about the reasonableness, a lot of people, the Pickett fairly debatable standard actually has not a reasonableness, but there's a second component. There's the is the claim fairly debatable, but then even if the carrier loses, that doesn't mean that there's bad faith. There's still a second element of the standard, whether the carrier recklessly disregarded the fact that it didn't have a debatable basis for its position. So, insureds do have, even with the fairly debatable standard, they have opportunities to conduct discovery. I think the problem is that more often than not, they're finding that the carriers have legitimate reasons for its positions. Like I said, they may not always be right, but they're certainly advancing those positions in good faith and with arguable basis.
Thank you.
Thanks, David. I have a couple of questions here just about the functioning of the court for you from participants that have emailed in. Did Justice Levicia ask any questions, since she is usually the swing vote? So let's turn that into a larger question of how did the justices participate, and then any sense of when the decision will come down?
Well, in terms of the Justice Levicia did not participate in the oral argument. Neither did Justice Patterson. I think the general sense from the insurance industry's side of things is that's somewhat unfortunate, because the general sense is that those two justices might have a good take on things from the defense side, from the insurance carrier side, a good understanding of what the carrier's concerns are. Neither of those justices participated. I don't know why. There was no announcement at the beginning. I don't know if there was any type of, if they felt if they recused themselves or if they were sick. I just don't know. I guess, as far as I know, there was no articulation as to why they weren't there. Someone else may have an understanding. I think that there was some speculation that some relatives of the justices may have had some relations with the firms that were involved. I personally don't know. I don't know if they will be, if Justice Levicia and Justice Patterson will be participating in the decision. In terms of the justices overall, again, Justice Alvin, in my view, was the hottest judge. He was the most active judge. He had the most questions. He seemed to be the most engaged. But all of the judges, the justices, to some extent, were asking questions. But my sense is that certainly Justice Alvin was taking a lead here. I thought that if there was a justice who possibly was leaning towards the insurance industry side, that might be Fernandez-Vina, based on the questioning. I guess those were the two justices who were most active in their questioning. And that was particularly so with respect to the first case. As for when a decision is going to come out, typically these will take anywhere from 3 to 6 months. In my experience, that's sort of my best guesstimate here as to when we'll see decisions in these cases.
Well, thank you so much for answering all of our questions. That's actually all the ones that I have in here. If anybody wants to get in a last-minute question, you can, of course, press 1 and 0. Otherwise, I just want to thank you, David, for doing this and also for doing the Institute's amicus brief in this case. We have that brief on our website as well as links to the underlying cases, the lower court decisions. For materials for this, if anybody needs to access that.